Happy New Year. Happy Friday. Thank you for tuning in today to our live broadcast. I am going to be discussing the truth about custody in Georgia today. And I am so happy that I have been able to provide you guys with some really good information. I've been getting great feedback and lots of love from you guys. So it just gives me confirmation that I'm doing God's work by empowering you guys with the knowledge that you need, because I believe that knowledge is power. And that is our goal, to empower you this 2018. So if you are watching our videos, you are equipped with everything that you need to know, and you should pursue and enforce your rights. So make sure this year for 2018, don't settle for anything less than what you are entitled to. But first, you have to know what those rights are. So as I go through the broadcast today, feel free to post your questions. And if they are posted actually during the live broadcast, which is today, Friday, January 5th, 12 o'clock, I will answer those questions before I log off. Some questions you think you're live and you're not actually live because you're viewing it later. That's why I'm not responding. So our team will go through and answer those questions after the broadcast is over and as you post them when we get a chance to get to them. Because I know that some people simply cannot afford legal advice, or that some people are just in the initial research part of their journey. The question and answer sessions that I do are very important to you guys. So with that in mind, this year, I will be doing a bi-weekly Q&A session, one evening out of the week. The first one is going to be this upcoming Wednesday, January 10th. It's probably going to be about 9:30 p.m. Follow our page to get that alert. And I'm doing it at night because I know when I do these during the day on Fridays at 12 o'clock, most people are at work and they're not able to tune in. So I want to make myself available to you guys on the evening so you can ask me your questions. We can just chat back and forth, and I'll address everything that I can during that time frame. So make sure you tune in this upcoming Wednesday and every other week to be able to have more of a conversation back and forth with me. Today, I'm going to be talking about the truth as it relates to custody in Georgia. As you enter into this new year, you need to know what the deal is as it pertains to custody cases. I've done other videos about this, but today I just want to knock out some of the myths and give it to you straight so you're not walking around vulnerable this year. I am attorney Joy Fairell. I'm the managing attorney here at the Fairell Firm. You've probably seen me a lot if you follow our videos. I just got new hair, same face. You'll continue to see me a lot this year, and you'll also be seeing Attorney Roy, who is a senior attorney in our office, and you'll also be seeing some of Attorney Kelly this year. Here at the Fairell Firm, we focus very heavily on family law litigation, which covers all things related to your family. That's custody, child support, divorce, adoptions, the establishment of your wills, power of attorneys, etc. In addition to that, the other part of our practice is some personal injury. So if you've been in a car accident and you were not at fault in that accident, feel free to give us a call if you need representation for that. If you want to know more about the Fairell Firm team, please head over to our website at fairellfirm.com, and you can check us out and make sure you stay connected with us by following us on Facebook, Instagram, as well as our YouTube page. By tuning in today, you are acknowledging that the information I am giving you is for informational purposes only, and it is based on the laws of Georgia. Every case is different, and you should seek legal advice if you need a specific advice to your situation. Sometimes you may ask a question and I really need more information to answer it thoroughly. So information that I'm giving is just for informational purposes only, and you need to reach out to an attorney if you need specific legal advice before you make any decisions. Again, I take questions at the end of the broadcast, so you can feel free to ask me any family law question, even if it does not relate to today's topic. You can type your question at any time and I'll get them in the order that they were received. So let's go ahead and get going. So the truth about custody is our topic today. The first thing to discuss is, when does a custody case come into play? Custody is addressed in divorce, legal separations, and legitimation proceedings. And a legitimation is a case filed by an unmarried father. So let's talk about the custody and a divorce first. If you are married and facing a divorce, or already in the middle of divorce, the most important thing to note is that mom and dad, i.e. husband and wife, or mom and mom, dad and dad in our same-sex marriages, have equal rights to the child if you are married. Typically, the myth is that the child goes with the mom, stays with mom, or moms make the decisions about what happens with the child, or she decides to move, she gets to take the kid or whatever. This perception is so far from the reality of what our laws say. Here's what I see all the time. The parties are married, the marriage breaks down, one spouse moves out, but they don't file for divorce. They're just living separate. The spouse who has kept the child starts to dictate when the other person can see the child, talk to the child, etc. And at some point, there's a disagreement. So one parent starts to be pushed out of the child's life at the hands of the other parent. This is not right. And if you are in this scenario, you need to put a stop to it immediately. If you are married, you can get your kids whenever you want to. You can go to the school to pick up your kids. You can take them to the doctor. You can make doctor's appointments for them. You can bring them to the house and they can spend the night with you for 5 days, 10 days, 2 days, whatever you want. You have that right as their parent, and no law enforcement can tell you differently. So just make sure you are aware of that. I do recommend that you communicate this with the other parent out of fairness before you just up and, take a child or remove a child. If you're going through a divorce, one thing you really have to learn is how to co-parent. So you definitely need to be communicating, but don't let someone dictate or limit the time that you have with your children. If you want to see your children more, then do that. If you want to see them less, that's fine too. The key here is not getting pushed into a parenting arrangement you wouldn't be okay with in front of a court order. But the reality is, if during the separation in the unofficial parenting agreement, you only see your kid 2 times a month, don't expect to go into court and ask for a 50-50 custody plan and expect to win. If you check out a video I did a few weeks ago, it was called Tips on Winning Joint Custody. That's one of the key factors I discussed, is establishing a parenting plan that you want in the long run. Establish it before you even get to court, and then you're going to be more likely to prevail on that plan. Now, there are a few exceptions to the if you're married, you have same custody rule. So the first exception to that is if there is a TPO, and a TPO stands for a temporary protective order, and that order may actually lay out terms of custody and visitation. That is a court order, and it would need to be followed until it is replaced by a divorce decree or until that TPO order expires. Now, people file TPOs left and right. If they've been threatened or they get in an argument, they run down, file a TPO. And honestly, a big mistake I see with this is when they go to court, they just agree to the TPO order, maybe because they're scared or whatever. I don't know, but TPOs actually need to be proved. So if you get a TPO issued against you, it's going to automatically be issued for 30 days. You're going to have a court date within that 30 days. And then when you go to court, the judge will decide should the restraining order be in place. Don't just agree to a restraining order. And if you are going to agree to a restraining order, or if you're going to be before the judge about the restraining order, you need to make sure you ask the court to only have you restrained from the spouse and not the children. Make sure the children aren't included in the TPO. If they're included in the TPO, that means you can't see your kids. So just make sure, a lot of times they get put in there by default. Make sure you say something like, if there's been no harm done to the kids, if you're not a threat to the children, make sure you ask the court to not include the children in the restraining order. Another exception to the married custody rule is if it is a condition of bond. So if you've been arrested for some type of domestic dispute or assault and you bonded out of jail, one of your conditions of bond could be to stay away from the spouse, and the children could also be listed in that condition of bond. So if that is the case, that means you do not have equal rights because of that bond being in place. You have to follow that. And on another side note, if you are a step parent, you don't have any rights to a child if there has been no adoption. I did a video on that. I believe it was last week. It was called Understanding Custody for Step Parents. These same terms apply if there is a legal separation case. Legal separations and divorces are almost identical, except at the end of a divorce, you're actually legally divorced. At the end of the separation, you're still married, but you may have already divided assets, the kids, in debt, and everything else. So the next thing I'm going to talk about is custody in a legitimation case. A legitimation action is a case that must be filed by a man who is not and was not married to the mother of his child at the time of birth. Fathers with children born out of wedlock do not have any rights to their children until they go through the proper legitimation process. Now, prior to July 1st, 2016, a father had the option to do what's referred to as an administrative legitimation at the hospital by signing a document. That option has since been repealed, and you now have to go through the courts to file a legitimation action. So if you have a child born out of wedlock, the mother is automatically the sole legal and sole physical parent. This means that moms have all the rights and all the say-so as to the well-being and whereabouts of the child. It absolutely does not matter if you sign the birth certificate. It does not matter if you pay court-ordered child support or slide her cash every week. It does not matter if the child lives with you. If a father has not done the legitimation action, he has absolutely no rights to the child whatsoever. Legitimations are not granted through child support recovery cases either. So if you've been to child support court, that does not address custody. Mothers need to be aware of their rights in this situation as well. And fathers have to be aware. Sometimes mothers will call and say, well, he came and took the kid, won't bring the kid back, blah, 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 blah. And if he hasn't legitimated the kid, you're out of your mind for letting him take your kid. So mothers need to know their rights, and fathers do too. The big thing here with legitimation, what moms need to know is that only a father can file for a legitimation, not you. So if you want the father to be active in the child's life, you have to understand that it's his choice and his right to pursue the legitimation action. Fathers, if you want to be in your child's life and have time with your children without having to request permission from the mother, you need to make sure you file to legitimate the child. These cases have to be filed in the county where the mother and the child live, and she needs to be served by the sheriff. And you need to make the request clear as to what type of parenting time that you are seeking in the petition. So let's talk about the types of custody that can be requested in any of these custody cases, whether it's a divorce case, legal separation, or a legitimation case. So there's two types of custody which have to be addressed. And those types of custody are legal custody and physical custody. Legal custody is the right to make major decisions on behalf of the child. Under the law, these major decisions actually fall into 4 categories, and these categories are education, healthcare, religious upbringing, and extracurricular activities. Legal custody can be held solely by one parent, or it can be held by both parents, and that's referred to as joint custody. And when it's joint custody, the parents don't necessarily split them 50-50. They can split them. One person can have one decision or 3 or joint on everything. It can go a different variety of ways, but the point is that it's joint and you guys have to make joint decisions together. The other type of custody is physical custody, and is usually the one most people are concerned with. Physical custody is who actually has the child physically, as in who the child lives with. If one parent has what we reference as primary physical custody, that means the child resides primarily with them. If the parents share joint physical custody, that means the child resides with both parents somewhat equally. So determinations in a custody case, once you are properly before the court on any custody case, the court will be entering what we refer to as a parenting plan that outlines who the child will spend each day of the year with. Parenting plans should be very specific, and you should avoid vague language like visitation will occur whenever the parties agree, because what happens when you don't agree? You won't have any visitation. Georgia law actually prohibits vague language technically if you read the statute, but some parties will create their own agreement and the court approves it without really looking at it, but the agreement may not be an airtight agreement. And that's where good lawyers actually come into play, because while you're thinking about today, we're thinking about the big picture and what will work for you for many years to come. So custody modifications. Although we try to make parenting plans that are for the long haul, sometimes things change. Actually, all the time things change. When this happens, the question comes up whether or not the custody can be modified from what it was originally. The answer is yes, custody can be modified, but in order for you to qualify for filing a modification action, you have to meet the statutory requirement. And what the Georgia statute said is that there must be a material change in circumstance that affects the well-being of the child. So you just can't wake up and decide you want to change custody just because. There has to be a substantial reason behind it to justify it. And easy reason, if a kid is 14 and decides they want to live with mom or dad, they can sign the affidavit saying that, and that affidavit in itself will meet the statutory requirement for change of circumstance. Other examples for change of circumstance may be if there's some type of abuse or one parent isn't doing what they need to do, job, issues and scheduling where one parent can't provide for the child like they used to. One parent, doesn't have a place to live. Stuff like that can put us before the court on a modification that we can request the change. Okay, so go ahead and start typing your questions because I'm getting to the end because I was planning to end the show right here. But literally while I was planning this out yesterday, someone sent me a video that had gone viral from the website called Media Takeout. And I'm sure maybe some of you saw it, but what that video showed was a mother and her two 11-year-old girl twins being arrested right here in DeKalb County for withholding the children from their father. The father lived in Alabama, and from my understanding, it was an Alabama custody order. And the warrant that was issued was for interference with child custody. And anytime you interfere with custody, let me not say anytime because these warrants are actually kind of hard to get. But if there's an interference with child custody, you can try to get this warrant. It's not a civil warrant, it's a criminal warrant, and it carries a felony with it. But anyway, so these police officers come to the door and they're knocking, and she turns on her phone and they let her know why she's being arrested. And when I watched this video, it broke my heart to hear these children screaming to the top of their lungs at the sight of their mother being arrested. I do commend the DeKalb County Sheriff Department in their professionalism in that situation because it could have been worse. But nonetheless, those screams really made my eyes water. And I was so glad I took the time to watch the video as I was preparing for this live show today, because it reminded me that I need to tell you guys to remember who hurts the most in cases where two adults are not willing to work together peacefully is the children. The children are the ones who suffer, and sometimes is irreversible suffering. So we just have to keep in mind that we're dealing with little human beings as we do these cases. In another situation I had last week, I was at the UPS store, and the guy working behind the counter asked me what kind of lawyer I was, and I told him I did family law. And he was like, "Oh, so is that custody?" And I was like, "Yeah." And he told me he was involved in a custody battle when he was younger. And he said the word that he used about that, he said the custody battle destroyed him, and he still had not recovered from the custody battle that his mother and father went through when he was younger. And this was a grown man. He had to be like 24. And so I asked him who won the custody case. And what he said to me was, more importantly, is who lost the custody case. And he said it was him. And so that was just so profound to me to think about it from that angle, especially as a custody lawyer. We always have to keep these children at the forefront. And I have to encourage my clients, male or female, and that is our philosophy here at the Fairell Firm, that if there is a good parent on the other side of the case, we encourage both parents to be involved with children. Now, some parents aren't equally good. Some parents are terrible. Some have drug problems. Some are pedophiles. I get that. I absolutely do. But if there is nothing wrong with that parent, then I completely support two parents being in a child's life so that you don't have a child that grows up and says that the custody battle they witnessed you go through literally destroyed their life. So with that being said, keep the kids first. Decide if you can agree on the notion that a child deserves two loving parents. If so, work together to create that reality. Then take it to a court of law and make it official. So I'm going to go ahead and go through and take some of these questions that you guys have been posting. And I don't have many, so that means you don't have much time to write. So Rashawn says, will this include information for grandparents? Rashawn, I don't know if you're still watching, but I have a show coming up on grandparent custody. I believe it's February 2nd or 3rd, whichever day that Friday is. That's going to be our show specifically for custody rights for grandparents. So you can make sure you tune in that day. And Venetia says, I'm gonna have to read this on the screen because it's blocking. If the child was born before 2016, but you aren't sure if the administrative legitimation was done, can you go back to the hospital for documentation, or where would you get this proof? Well, this was actually part of the issue with the administrative legitimation. It's like if it was done, it just disappeared into La La Land. Now, it depends on where the kid was born, the hospital record keeping. Where it's supposed to be is in the Department of Vital Records, and that's the same place you go to get your marriage license and birth certificates. So you can check there, and it'll be almost like at the bottom of the birth certificate. It looks like that document. Then it'll say like acknowledgement of paternity, and it'll be like a little paragraph with dad, citing OCGA code section saying that the dad is saying he's the biological father. And then right under that is like a paragraph that says legitimation, and in that it will be saying that the father is signing to legitimate the child. Now, what's important to note, if there has been an administrative legitimation, the child is the legal child of the father. So yes, he technically has rights, but the error in that administrative legitimation, it doesn't lay out what the rights is. So I'll walk out of the hospital, have legal rights to my child, but nobody's told me what those rights are. So does that mean the child gets to live with me? No. So then what we do, if there has been an administrative legitimation, we petition the court to, and we call it a determination of custody and visitation, or establishment of custody and visitation, because we still have to establish the custody and visitation plan. What we don't have to establish is whether or not the father meets the statutory requirements to be able to legitimate the child, making the child legally his. So we get to skip that whole part of the case and go right into the custody and visitation part, because your legitimation right, you can't wait 10, 15 years to file legitimation. There's like no set time frame, but you can't wait forever. And it can be denied. And it has to meet statutory elements for the court to grant legitimation as well. I'm not even going to try to pronounce this name. Mr. Starks, I think. I'm assuming it's a man. Who has legal custody of child if mom dies and child is not legitimized? Not you. I can say that. So what you need to do if this happens, you actually need to file a petition to legitimate, and you need to file it against the deceased mother so you can get those rights. And her mama don't have rights either, like literally nobody. And this is why it's really important to get those legitimations done, because if something does happen to the mother, you leave your child open and subject to state custody. So if mom has died and grandma or somebody is taking care of the child, and you can go ahead and file the legitimation still legitimate the child, so long as the child is living. Okay. And that's all the questions I see for right now. I do want to let you guys know again, Wednesday, this upcoming Wednesday, January 10th, I'm going to be going live at like 9:30 at night or closer to 10. So we can have some evening chats when y'all are at home. And I'm going to be at home too, so I'm not going to be in my office. So don't say I'm not professional, because I'm going to be at the house. But I'm going to be taking your questions, and we can just chat back and forth. So make sure you follow our page, so when I put out the alert for what time it's going to be, that you get notified. So you can send in your questions and we can have a conversation. I'm going to try to do this more frequently, because I understand the afternoon hours are difficult. And I also want to tell you guys, we're going to be launching our podcast really soon. It's going to be called Law Talk Live, and we're going to be featuring some of your situations. So if you want to be featured on our show and you got a situation you want to talk about, go ahead and submit it to us at support@fairellfirm.com, and our entire show will be about you and talking to you and about your situation. So we're going to give you some legal advice with a twist of street advice, because that's how we operate. We're down to earth, but also very informed on the law. So y'all keep a lookout for that. I'll let you know. The last question I have here is there a way to legitimize a child for free? Nothing in life is free. So I'm going to say technically no. But if you can't afford the filing fee, you can file what's called a pauper's affidavit, indicating you don't have income and you can't afford to pay the court the fee to file the case. It's usually $200-something. So it's free in that sense. And if you can't afford a lawyer, you can always try to get qualified through legal aid, and they free to you, but not free to, our tax dollars pay for that. So you could try legal aid, or you can do it yourself. That's free. But sometimes the mistakes you may make doing it pro se may end up costing you in the long run. Quentin says, what's the first steps in? Quentin, first step is file the legitimation. Well, first step is probably want to talk to a lawyer to make sure you're good to go. But if you're going to do it on your own, file in the county where the mom and child live, and go from there. You can also check back on our page, Quentin. I've done a video. It says it's called What Unmarried Fathers Need to Know, and it gives you those step-by-steps that you need to take in order to legitimate. So go watch that video on our page, and it's also on our YouTube page, which is under my name, Joy Fairell. Watch that video, and it'll tell you every single thing that you need to know. Miriam says, can my child's father change her last name even if he is not on the birth certificate? He's supposed to be paying child support but not paying. If he is not legitimized the child, no, he has not. A lot of fathers petition to have the child's name changed in the legitimation action depending on the age of the child. A lot of judges will let them do it, or they can hyphenate, Martinez and then whatever his last name is. But just as it stands right now, he's just paying child support. He don't even have standing to bring a case to change the child's name. Okay. So that's going to be it for today. I thank you guys for tuning in. If you do want to come into our office to meet with us, you can give us a call at 678-973-2803. We do offer consultations. Those consultations are $150, and it gets you an hour with myself or one of the attorneys in the office. And we'll sit down with you, talk to you, see if you have a case, and we'll give you all the advice you need specific to your situation. You can also book your appointment online at fairellfirm.com and go from there. So I hope you guys have a great weekend, and make sure to be on the lookout for Wednesday night. I'm going to be going live late Wednesday night, and just chatting back and forth with you guys on a more casual setting. So I look forward to seeing you guys in a few days. I will talk to you then. Have a blessed weekend.